Good morning, everyone. This is Pat McParlin from Opus. Welcome to our webinar, Countdown to GDPR. This morning, I'd like to welcome our speakers, Richard Seville, Solution Consultant, and Dov Goldman, Vice President, Innovation and Alliances, both from Opus. Richard Seville is our GDPR expert. He has been at Opus and previously Alacra for more than 5 years, and is the architect of our GDPR solution as well as an expert in the regulation. So welcome, Richard. Dov Goldman is our Innovation and Alliances expert. He is an expert in third-party risk as well as information security. He has been at Opus, previously Hyperos, for 3 years and speaks regularly in the press about information security. Welcome, Dov. So with that, I'd like to speak a little bit about Opus's mission, as usual, at the start of these sessions. Our mission is to free your business from the challenges and complexity of managing customer, supplier, and third-party risk. And one of the challenges and complexity of managing risk clearly is regulation. And the reason that we did this session is because we have had many, many questions about the GDPR. What does it mean to third-party risk, and what does it mean to managing that? And so we put this together to connect you with our experts and talk a little bit about how we can find the opportunity in GDPR. And I mention opportunity because, as always, we here at Opus see risk management and compliance not as a burden, but as a way to free you from concerns from specific regulations, to find new, better ways of doing things to improve efficiency and effectiveness. At the end of the day, the idea is to focus on your priorities and better serve your customers so that you can grow, innovate, and thrive, not worry about the regulation, but worry about the outcome and the business that you need to drive. So we'll cover a few different things today. This session is being recorded. We will cover the basic provisions of GDPR. We're going to focus on those that relate to third parties. We'll talk about how GDPR impacts third-party management, and Dov specifically is going to outline a few key steps that talking about managing third parties to ensure compliance with GDPR. So with that, I'm going to turn it over to Richard, and Richard will talk about the GDPR and specifically Articles 28 and 30, the two that we've been asked about the most. So let me turn it over to you, Richard.
Thank you, Pat, and welcome everyone to today's webinar. As you can probably guess from my accent, I'm from London and resided in London, working for Opus for just over 5 years. Both Dov and I are looking forward to a lively session, and there will be an opportunity to ask questions at the end of the presentation. But if you want to use the chat facility on the webinar, please free to add questions as we go through the presentation. I just wanted to start off with a little bit about what GDPR is, just for in case there's anybody in the audience who's not aware of GDPR. I'm absolutely certain by today that pretty much everybody on the session will know what GDPR is. But it builds on the Data Protection Act of 1995 and elaborates on existing principles. Pat, if you could just move to the next point. Thank you. And in addition to elaborating on existing principles, i.e. transparency and consent, it adds new principles such as concepts of privacy by design and by default, the right to data portability, the right to deletion, or the right to be forgotten. And the regulation has been modernized by adding online identifiers and location data. In addition, special categories of personal data gets greater protection. I would just wanted to add that obviously GDPR applies to non-EU organizations if they offer goods or services to EU residents. So that's basically a very quick overview of what GDPR is about. We go to the next slide. Okay. And the regulation itself, obviously, I've been involved in the regulation since 2016. when I began to look at the regulation in regard to our two existing product lines, both the Alacra products and the Hyperios products. And if we just click through, I just wanted to share some information about the regulation. It's 88 pages long. There's 173 recitals, 99 articles in 11 chapters. It's a good read. I would recommend it to anybody who's interested in the subject, particularly to read the 173 recitals. But what we want to talk about today is Chapter 4, which pertains to controller and processors, and specifically Articles 28 and 30, which apply to processors and the need to maintain records of processing activities.
Richard, if I could ask a question. Good morning, everybody. Doug Goldman speaking. Is it the focus for anybody who's worried about GDPR compliance in their third-party population, is that focus in Articles 28 and 30, or are there any other parts of GDPR that our audience has to be concerned about with regards to their third parties?
No, I would say that Articles 28, 29, and 30 specifically address the concerns of a controller and its use of third-party processors. Although having said that, it's obviously advantageous to understand Chapters 3, the rights of data subjects, as well. And I think probably as well Chapter 2 in regard to principles. But the meat and potatoes of control is in 28, 29, and 30. So what do these articles cover and why do they matter? One of the things to really understand is the difference between a controller and a processor of data, and to understand the new regulatory obligations on the processor, but also the new reporting obligations for both controllers and processors. A key change in the regulation is that the processor is now covered under a legal obligation, whereas in the Data Protection Act of 1995, it was only the controller. So I'd like to go to the next slide and talk a little bit about controllers and processors. The data controller is really the boss. He's the owner or receiver of personal data, and he dictates which personal data is processed, how, and why. And the data processor is the worker, the party processing data on behalf of the controller. So, Pat, if you click through, that's great. And then if you click through again, the controller is responsible for processors' compliance with GDPR. So it is vital that a controller understands what is happening with their data and can ensure that their processors have controls in place to ensure compliance with GDPR.
And Richard, that need for the data controller to oversee the processor's GDPR compliance, is that specifically written into the GDPR regulation?
Yes, it is. It's in Article 28. If we flip to the next slide, and you can see there it's Articles 1 through to 3. A controller that wishes to appoint a processor must only use processors that guarantee compliance with GDPR. So it's very clear in the regulation. So what data privacy controls are needed for third-party relationships? So if we move on to the next slide. And this is the only slide where there's a lot of detail. Basically, the regulation states that there has to be a binding agreement in writing between the controller and the data processor. And there are certain key things that the controller has to agree to. And the first one is only to act on the controller's documented instructions. What is quite interesting about this is that if a processor goes beyond their contractual responsibility in regard to data processing, they automatically become a controller. So it's very clear in the regulation that they can only act on the controller's documented instructions. If they do anything more, they become a controller under the regulation. The next item is that they have to impose confidentiality obligations on all personnel dealing with personal data. And the next one is they have to ensure the security of personal data. Now, the fourth rule is that if the data processor wants to appoint a sub-processor, they need to get written permission from the controller, and they have to also assist the controller in complying with data subject rights. That's the next bullet point. The next bullet point is that they play an assisting role with the controller when dealing with the data protection authority. So for the UK, that would be the Information Commissioner's Office. And finally, they have to return or destroy personal data at the relationship. There was one final point I missed, was they have to provide all information required to demonstrate compliance. And that's an important element of this binding agreement.
Richard, I'd like to interject that the recent Facebook breach comes to mind here as I'm looking at your slide. It's clear, or at least it seems clear, that Facebook would not have been liable under GDPR because the 50 million profiles that were released to Cambridge Analytica and used for political purposes in the 2016 elections, they were U.S. citizens. And tell me if I'm wrong, but GDPR really doesn't cover U.S. citizens. But had we had a law like GDPR here, it seems that the third party that had access to the Facebook data, that was a Professor Kogan, would have had some kind of contractual obligation, specifically what you're showing here, and would not have been able to pass that data on to another third party, or really, classically speaking, a fourth party that then went ahead and used that data in an inappropriate way against the consent that the data subjects, the individuals whose profiles were given out, would have wanted. So would you agree that it's really relevant, even though the law doesn't cover Facebook, that the principles here in GDPR are extremely relevant to this very, very widely publicized case of data leakage?
Yeah, I agree, Dov. I think the overriding principle of the regulation is, it's been written to protect the personal data of an EU citizen, wherever that data is kept in the world. I know we had a discussion on this the other day in regard to what about US citizens protection. We don't cover that in this regulation. So any non-EU individuals affected by that would not be covered under GDPR. But the general principle of ensuring security of personal data, that would come under the regulation. So if we move on, so the next question really is, on the next slide, is must we apply the same level of oversight and control to every third party? Not necessarily.
Let me, Richard, if I can interject here, that our general approach to third-party management in other risk domains besides GDPR, which is really a form of a privacy domain, is always to adopt a risk-based approach, because there's never enough resources to do everything at the same level with every third party. Can we adapt that method here, that approach, a risk-based approach, to third-party GDPR compliance?
Yeah, I agree, and that is why we use a methodology here called the 5 Ws. And basically, the questions that you need to understand is whose data is being handled, what type of data is being used, when was it obtained, where is it being processed, and why is it being processed. And this is quite important because there are certain elements of personal data that have higher risk levels. So, for example, if I'm holding bank account information or health information, or details about somebody's sexual orientation, that data would pose a much higher risk to my organization should somebody hack into my system. And the other thing that is relevant is, you know, what is that information being used for? Is it for the provision of goods and services to a customer? Is it for the prevention of money laundering? So there are a number of questions that you should be asking and you should understand. So, for example, what is the lawful basis for processing? Is it based on consent? As I said before, is it based on contractual? Or are you doing it because you have a legal obligation? So all of those elements, those 5 Ws, are essential for determining the inherent risk of your supply chain. And here at Opus, what we also do, we use those 5 Ws to not only calculate inherent risk, but we marry those data elements up with a set of assessment questions that we use to measure control, the extent of control that a third-party processor has over the personal data that is being processed by them. And obviously, the higher level of control means that you're able to reduce the overall residual risk for that service. So if we go to the next slide, I just want to show you.
Actually, Richard, this is Pat. I want to interject. Dove's commentary on Facebook stirred up a flurry of commentary in the chat room here. So there are several comments that although the GDPR is not yet applicable here, seems to be the precursor to data practice law to come in the U.S., several comments like that. But then the question and a comment that U.S. citizens would be covered by GDPR if they're in the EU, correct?
No, I didn't say that. I said that the GDPR regulation is for the protection of EU residents wherever they reside. It would not protect
right.
U.S.
But it wouldn't. The question is, U.S. citizens would be covered by the GDPR if they're in the EU. If they reside in the EU.
If they reside in the EU, yeah.
Okay, good. So we got about 3-4 questions on that. So, okay, cool. Thank you very much.
All right, so if we move to the next slide. Okay, this is an example of a risk-based approach, and it's an example of a report that we produce out of our application. And it's a very simple report that outlines who the supplier is, what services do they produce, or what services do they provide to the company. And then we score the inherent risk based on the 5 Ws. We look at the control effectiveness and we apply the control effectiveness to calculate residual risk. And you can see in this report visually where your high risk processes are. And if we move on to the next slide, which is really focusing in on Article 30. And Article 30 is a very important piece of the regulation because it outlines what information needs to be made available to the regulator if they should ask for it. So the regulation doesn't say you have to produce a report and send it to the regulator. What it says is you need to have access to this information should the regulator require it. Of course, it's good practice to have a record of processing activities as part of your day-to-day commercial relationships with a supplier. And what this report here shows is the information that is required by the regulators. So it will show the contact details of the controller, the representative, or the data protection officer. It shows you the purpose of processing, the categories of data subjects and personal data processed, and categories of recipients with whom the data may be shared. There's information in regard to cross-border data transfers, and it also asks questions in regard to the retention period and a description of the security measures implemented in respect to the processed data. And I want to talk a little bit about the description of security measures, because I mentioned earlier that as part of our assessment program, we have a number of questions that have been designed based on guidance from the regulator, so guidance from the Information Commissioner's Office, and we've devised a set list of questions. Not only are they based on the guidance from the regulator, but they're actually mapped back to the article within the regulation. And that combination of the guidance by the regulator coupled with mapping to the regulation itself enables us to calculate how effective the control is by the processor on meeting their obligations under the GDPR. And that's why we're able then to create a traffic light system to show that the residual risk of a supplier, its control effectiveness, and its overall residual risk at the end of the process. That's all I wanted to say on Articles 28 and Article 30, and I thought this would be a great opportunity to hand over to Dove to talk about the key steps that could be used or the good practices that should be used to manage third parties to ensure compliance. So over to you, Dove.
Thank you, Richard. So we're showing on the screen right now an illustration. I happen to think it's a wonderful illustration, but we're proud of authorship there. We had a big part of this. Published by OSEG. I think we're going to show you a link to this later on. But this is a cookbook for good, solid best practice in GDPR compliance. And one of the things we talked about earlier today is that GDPR compliance in the third-party spaces, it resembles third-party compliance in a lot of other risk domains. There's a process that you follow that I think you're going to find extremely familiar if you're very familiar with, if you have good best practices in general in terms of how you manage your third parties. So let's start that along. Pat, can you move on to the next slide? So you have a population of third parties that are, well, are they relevant to GDPR? So the first thing you have to do is you have to segment them. Again, this is very similar to what we do in all other risk domains. We have to figure out, number one, are they relevant? Well, are they processing our customers or some other form? Employees, personal data, employees are also covered by GDPR, very, very relevant to GDPR. Are they processing that kind of data? And we want to figure out what level of risk they expose us to, as Richard said earlier, the 5 Ws, so that we can classify them in terms of the level of due diligence we're going to perform. So there is a risk ranking, again, very, very similar to all the other risk domains in terms of how you break them up, how you triage them so that you can apply the appropriate amount of effort in each case. You can go on to the next slide here. So I just want to draw attention to this orange disc that you see in all of these images. It's plucked out of the center of that illustration, and this is intended to symbolize the data protection office or the data protection officer's oversight over this whole process. And the goal here is to create a principle that I'm sure some of you have heard of and are aware of or thinking about it. It's privacy by design. I think that is the intent, in my opinion, of GDPR. It's our responsibility to the people whose data we are taking to process that data in a way that's consistent with what we've told them, what they've given us consent for, or what we have the right to do under legal reasons, and to make sure that we're always handling that data in a manner that's beneficial to that data subject. And so this is a very basic thing that I think as individuals we should all be concerned about, but it should be the guiding light for the process here. So we now have a population that's been broken down into relevant from a GDPR perspective, not relevant from a GDPR perspective. So we're going to forget the not relevance right now. We're going to focus on the relevant, and hopefully it's a much smaller population than our full-blown third-party population. We're going to exclude the people who sell us pencils and cut the grass at our headquarters, and we're going to focus on the outsourcers who actually do things with our data, whether they're co-location providers and they have huge amounts of our data, but they're not dealing with it specifically in a structured way or processing it specifically. Another example would be those that are actually doing things with the data. So I always, when I explain what we do in GDPR to some of my friends and relatives, I talk about the example of your bank account. Of course, everybody does. And you get checks printed. And so who prints those checks? It's not the bank. It's one of two very big check printing companies. Well, guess what? They have your name, they have your address, they have your bank account number. Okay, well, that's a classic data processor under GDPR, and that's going to require a lot of focus. So we now have these populations broken down. We have them segmented into different levels of risk, and now we're going to apply, just like in InfoSec or BCPDR or any of the other domains that fit into that basket, we're now going to have different levels of investigation that we do. And so we may, in many cases, just use an internal risk assessment. We may ask questions of internal stakeholders that hold a relationship to find out risk is low with a group of third parties. When it's a medium level risk, and I'm just giving an example of 3 levels of risk here. In a medium level risk, we may issue a questionnaire to the third parties, and then we're going to score that questionnaire, have some kind of an approval process. And then when we're talking about those high-risk processors, now we've got organizations that have several million of our customer records, and they're doing things with them. Well, that's higher risk. There we might want to do some kind of an enhanced evaluation and on-site like we do with InfoSec. And so there's a whole spectrum of things here that fit into this category of controls assessment. For the vast majority of third parties, it's probably going to be a combination of collecting data from internal stakeholders, what is often called a materiality assessment, or risk assessment questionnaire, IRQ, internal risk assessment questionnaire, everybody's got a different name for it, and an external questionnaire that's going to attempt to tease out what kind of a job are third parties doing in terms of the controls. How effective are their privacy controls? Do they satisfy our requirements under GDPR, their requirements, because as Richard told you, they are obligated under GDPR. Okay, so let's move on to the next step. We have done our controls assessment, and we're going to probably in some cases find out that our data processors may not be fully buttoned up. There may be some gaps in their controls. There may be, for example, the classical one under GDPR, the problem that anybody who processes data should be by now trying to rectify is, do they ask for consent from their data subjects? Do they make sure that they've gotten the right to process that data and they've been specific in telling the data subjects what they're going to do with the data? And then do they have technology in place that enables them to implement things like right to be forgotten? Key part of GDPR is you have to be able to call up or contact the companies that are processing your data and say, show me my data. Let me edit my data because there are mistakes in it. You know, we all have that problem with our credit reports. And you have to be able to say, I want you to forget my data. So you're going to be checking for those controls. And I think that in many cases, we're going to find that this is an area where remediation is required, where the data processors don't have those capabilities in place yet. And so this is also very much like InfoSec. It's really very similar. This is a part of InfoSec. Data privacy is very much a part of InfoSec. So I need to be able to deal with the remediation process in some kind of an efficient workflow way. Can we go on to the next slide? Last step. I say this all the time. I hear this at conferences. I think most people, virtually everybody agrees that any kind of an assessment done on a third party is inherently a snapshot in time. I'm looking at their controls now. That tells me hopefully it's predictive of the quality of their controls, the effectiveness of their controls 3 months from now, 6 months from now, 9 months from now. It may not be, and there may be changes. So ongoing monitoring, there's a lot of disagreement about what that means, but I think most people agree that it means that there's going to be a cadence of repeat reviews. For the riskiest of vendors, it's going to be every year. And then as you go down the risk pyramid, you're going to make those less frequent every 2 years, every 3 years. And in more and more cases, more and more of our customers are saying they'd like to have a way to look at their third parties in between those reviews, and they may actually modify the cadence of those reviews based on the information they collect. And there are many ways to do this. More and more we're seeing customers saying we'd like to use technology-based approaches to monitoring. We'd like to consume IT threat feeds, and they often call them validated vendor information security practices data feeds. And so these are useful tools that enable you to have a look at your vendor, see what they look like, and these tools are non-invasive. They can only look at the internet-facing surface, a term that I'm hearing more and more often of their organizations, and that really is part of your front-facing surface now. So you want to look at that, and these data feeds provide the ability to do that on a regular basis and to manage changes in your vendor's controls on an exception basis, which is really the only efficient way to do it if you have a large group of vendors. And so we're seeing more and more of that where customers are saying, I want to use a data feed to look at my data processors on a regular basis more frequently than I could possibly do some kind of an assessment. And so that kind of fills out the cycle, and I'm sure that anybody who's a professional, a real practitioner in third-party management recognizes I haven't told you anything new that's specific to GDPR. This is privacy. GDPR is privacy. Privacy is part of the InfoSec sisters, I call them, BCPDR, InfoSec, and privacy. So it's a very, very similar process. I think at this point we can open up the floor to questions. We have some time left. We finished mercifully early, and so we can cover some questions, and then we're going to let everybody go and have a little extra time in your day. So, Pat, do we have questions that have come in?
Yeah, we do. Thank you, Dov, and thank you, Richard, for the presentation. And a couple of the questions are tactical about the presentation itself. So will you receive a copy of the presentation and the slides? The answer is yes. Everybody on the call will receive those, and we'll also send you a link to the OSEG diagram that Dov referenced, which is, I forget what you called it, a roadmap or a chart. Is an excellent resource, so we'll send you a link to that as well. And so that's the answer to the first question. So a lot of the questions are still around the topic mentioned earlier. So I'm going to read you one of them about the coverage around people in the EU from other countries. So this one says, are not persons in the EU covered whether or not they are EU citizens? In the case of a USA citizen being in the EU, they are covered to the extent the information is generated in the EU. Is that not true? GDPR covers anyone resident in the EU, not just citizens. Can you clarify?
I can. Yeah, it is residency, not citizenship. So if you're resident, yes, you would.
Okay, excellent.
And Richard, if you're resident in the EU and you place an order for some shoes on a U.S. website, is that still within the scope of GDPR?
That's quite interesting because if you look at recital 23, it talks about companies offering goods and services to an EU resident. So, for example, a shoe salesperson in the US offering the ability to purchase their products via a website in Europe, they would have to comply with GDPR. But if anybody is really interested in that topic, I'd recommend reading Recital 23, which goes into how the regulation is going to treat purchases or offers of sale from companies outside the EU. I'd read it to you, but it's quite tedious. But it's Recital 23 is the one you should look at.
Okay, thank you, Richard. As a reminder to ask questions, use the chat button on the GoToWebinar. So this question is about the definition of controllers. What if it's a partnership, not a vendor, such as a credit card processor that co-markets with the FI? Are both technically controllers?
To be joint controllers.
Richard, does that change the obligation of the bank to do an assessment of the credit card processor's GDPR compliance?
No. No. So joint controllership is covered under Article 26. And I'm just taking a very quick look at that now. But the same obligations would apply. They would still have to comply with the requirements under GDPR. But specifically under regulations, there is a concept of having joint controllers. And they would be equally liable under the regulation.
The next question is about one of the, yes. So the next question is about one of the points that you made about the data processor agreements that have to be written. I know that the data processor agreements have to be written, but do they have to be signed by both the processor and the controller?
Correct. Correct. And what a lot of companies are doing these days, and what we're seeing this with our discussions, are that everybody is repapering their third-party supply chain, which is fine, but it doesn't really give you any basis for understanding the controls in place by that supplier. So I don't think it's a case of just repapering and having a third-party supplier attest to the fact that they are in compliance with GDPR. I think it's prudent, particularly with your high-risk suppliers, to go deeper than that and to actually submit them to a much deeper assessment of the level of controls that they may have in place. And in some circumstances, it may require, a physical audit of the supplier to ensure that they have all of the controls required. But certainly, just papering a third-party supplier and asking them to sign off that they're compliant, I would think would be insufficient in case of if there was a data breach, for example. I don't think just having a signed contract would be sufficient evidence for the regulator to say that you've done your due diligence on your supply chain.
Thanks, Richard. And Dov, feel free to jump in on the answers as well. So this one is a broader question. What are the implications for firms that use third-party software for CRM, particularly those that host customer information in the cloud?
A great question. I think, go ahead, Richard, please.
No, Dov, I'll hand that one to you.
It's clear to me, though I want Richard to weigh in if I'm not speaking correctly. He really is much more expert in the regulation itself than I am. That is a classic case of a data processor. You are the data controller. You're determining that your customer records are going to be in that CRM system, like a Salesforce or something like that, or something banking specific. And they are your data processor, and therefore I think all the obligations apply. Richard, would you disagree?
I wouldn't disagree. I just sort of a bit of an anecdote. I heard that certain CRM providers when they were building their applications, many years ago, didn't take it on board that somebody would want to delete specific personal data from their application. So I know that some of the big players find it a challenge to remove data records. And I think a lot of people are using techniques such as overwriting data so that it's not readable, but is actually kept as a record within the solution. But yeah, it's certainly a challenge out there.
And the challenge of deleting data is a broad one, because as an industry, the computer industry has been very focused on preventing deletion. So if you look at your typical highly professional data processing operation, there's a pyramid of backup. You're typically going to be syncing your data over to a backup site for disaster recovery purposes. And then you're going to be doing all kinds of things in terms of tape. So I think more and more people are moving to optical and magnetic backup of other kinds. But so just to visualize this easily, that let's just say you have one of those robotic tape systems, and you have multiple tapes, and then you take tapes off site and you send them to Iron Mountain or something like that. What a huge challenge. Richard, those backup tapes that have been sent to Iron Mountain, are those have to be erased if the customer, if the data subject says they want you to get rid of that data.
Yeah, so in that case, obviously, if you go through a recycling of your backups, after a number of iterations, your backups will no longer have that deleted information in them. And I think that the regulator has to take into account that whilst the main book of record can be immediately deleted, that it would take a period of time for that to take effect on backups, for example. But certainly it would be a requirement, but I think in practical terms, you would have to wait till the full cycle of backups was complete before that record was removed from every single backup tape that you have. That's my view. I don't know if we have any comments from attendees on the webinar, but I think you have to take a practical approach to GDPR, and particularly in regard to data management.
What about Brexit? So how does Brexit impact GDPR and vice versa?
Well, we haven't Brexited yet, although the country has voted for it. The government has made it very clear that doesn't matter what happens, GDPR will be applied. In fact, the British government were one of the main drivers behind the GDPR regulation, working very much with the European regulators. So, as a country, we're very much in favor of GDPR and are in the process of adopting it into our legislation. Now, I'm not certain of the timing of the legislation at the moment, but today it has not yet been enacted as a UK regulation. It hasn't passed the House of Lords or the House of Commons yet, but it's in the process of being adopted. I think the only countries that are fully adopted it are Germany and Austria at the moment.
So back to the processors and the controllers. Will the processors get penalized under GDPR, or would only the controllers get penalties?
Both would get penalties. This is what's new with the regulation, is under the Data Protection Act of 1995, it was only the controller that would be fined under the regulation. Under GDPR, both the controller and the processor would be deemed liable and both subject to fines.
Okay, from a U.S. perspective, how about a company only doing business in the U.S., for example, your shoe shop example, report to? Which DPA or supervisor authority? The shoe shop may hold data from people in many EU countries. What would you recommend in this case?
They have to determine which is the. I'm just checking the reg on it because they have to choose the regulator where they do the most business in regard to who they want to be subject to from a regulatory perspective. So if the bulk of their business was in Germany, then they would report to the German regulator. If the bulk of their business was in the UK, it would be the Information Commissioner's Office.
This is an interesting question/comment. Thank you, Sarah Bailey, for asking this question. I'm situated in Sweden, and I found that about 1 in 50 companies has even heard of GDPR. How is it in the rest of the EU/world? And so this is me now editorializing, but I think it would be interesting to comment, on what you're seeing in terms of people's compliance rates and that sort of thing, and any other commentary you have on that question.
We see a lot of surveys and a lot of companies publish stats on this. I don't know what the latest figure is, but I would say a third of companies in the UK are aware of GDPR across all businesses. I would think, within financial services, for example, pretty much everybody is aware of GDPR, and everybody within financial services would have a GDPR program of work. But outside of financial services, I think some typical areas that are very aware would be charities, because there's some major changes affecting them. But general, manufacturing, for example, I would think it's pretty low. But I would say that the Information Commissioner's Office has got massive publicity over the last couple of weeks, due to the Facebook incident. And I think that, the pictures of data police going into Cambridge Analytica wearing what look like FBI jackets, but are actually ICO enforcement officer jackets, has caught a lot of people's attention. So, and the ICO itself has done a fantastic job in regard to putting information out there on its website, having conferences, webinars, blogs, etc., etc. So I think the UK, from a publicity point of view, is doing a very, very good job. And as I said, the recent incident with Facebook will certainly mean that every single executive of a large company in the UK will know who the ICO are and what they're about. So, yeah, I think the alarm bells have been raised. But will they be ready by May 25th? No. But a lot of people will today have been operating under the Data Protection Act of 1995. So they would already have good data practices in place. And, the requirements of GDPR, whilst there are additional requirements under the regulation, I think it's pretty much down to good data practice. And if people are following the DPA of 1995, they should be in pretty good shape. And the regulators made it clear that they will allow some leeway in regard to being fully GDPR compliant, as long as companies are showing that they're moving in the right direction and have a good process in place. Does that answer that question?
Yeah, no, it makes sense. It's interesting, you sit in different perspectives, you're sitting in your seat in the UK or the US, so you hear about this all the time. I just thought it was an interesting perspective. So what are the requirements of intra-company data transfers? For example, US office processing, receiving data of EU employees?
Well, firstly, intercompany transfer of data is covered under binding corporate rules. And there's a whole section within the regulation that talks about that. And there are special permissions that you have to get to transfer data within a group company. So that's if anybody's interested in that, it's take a look at binding corporate rules section of the regulation. And the second part of the question, Pat, I missed.
One moment, please. For example, U.S. office processing receiving data of EU employees. The first part of the question is, what are requirements of intra-company data transfers?
Yeah, so that's under binding corporate rules. In regard to personal information, the one thing they should check is that they've got the required level of consent from their UK employees to use personal data. It's quite an interesting one because a lot of HR departments in Europe are saying, oh, we may not have the appropriate level of consent from our own employees to use their personal data. So I think that a number of consultancies and lawyers are busy drafting new employment contracts to cover that. But certainly, yeah, they would definitely need to review employees' consent to use their data.
Great. So we do have a few other questions, and I think some of them will be better answered by you one-to-one. So I will relay these to Richard and Dov, and the question askers will receive individual emails. I would like to thank you as presenters and ask as a final question if you have advice for the audience, facing down the May 25th deadline, less than 90 days away now, to point out the obvious there. And so thinking about, facing down that deadline, what advice do you have as a wrap up for the audience, as we count down to GDPR? What are the key things that you would leave the listeners with today?
Yeah, okay. So number one, it's all about awareness. And the best place to go is to the Information Commissioner's website. So that's www.ico.uk.org. Highly recommend going to that site. There are a number of other sites on the internet that I've used that are very, very good. So if anybody's interested, I can send them some links. I would certainly encourage you to take a look at our website at www.opus.com. There's some good information there, some good blogs that you could take a look at. But I think the main piece of advice, even though May 25th is a couple of months away, don't panic, but treat it with urgency, and make sure that everybody in your company is aware. This is not an IT project. This is a project that affects most parts of your business, so marketing, HR, et cetera, et cetera. So, make sure that the board of the company is aware of GDPR. Make sure that they understand the need to appoint a data protection officer. And yeah, just follow the guidelines published by the ICO, and I don't think you go very far wrong. But we're here to help Richard, if anybody.
And if I can add one thing here, to quote a very smart colleague of ours, the unknown unknowns can't be managed. If you get to work to uncover the information about your third parties that enables you to segment them, to classify them according to risk, just like any other risk domain, as we said earlier, you have to talk to your internal stakeholders to learn about the third-party relationships that are data processors, to know where you have to go deeper. The first step, as in any third-party process, is to figure out what your population is and to divide them up according to risk.
Yeah. Great.
Well, thanks. And knowing you two gentlemen, as I do, I feel safe making the offer that I know both of you are available as a resource if anyone on the call has individual questions. So I will include your contact information in the follow-up as well, along with the links that you mentioned. That would be terrific. Richard, any more in-depth links around the GDPR areas that you mentioned? And I'll include these links on the screen as well. The GDPR page of the Opus website has some good blogs, some information, some good white papers that you mentioned information about the Opus solution as well. And then I will include a link to the OSEG cookbook. That's the word you said, Dov. I was trying to think it was roadmap, but it was cookbook. The GDPR cookbook, which is quite an excellent resource as well. So I'd like to thank everybody for coming today, and thank you for your questions and your commentary, and thanks to our presenters, and we look forward to seeing you or hearing you at our next webinar. Thanks, everybody, and have a great day.